All right, you ready to start?
I'm ready to start.
Okay, today's lesson we're going to talk about the exclusive buyer agency agreement. Now, keep in mind we're in the agency section, and so part of this section will be not only understanding agency, but also understanding the contracts that go therewith.
Awesome.
And so to start off with, I know it seems like a minor thing, but I want to start with the name of the form, the exclusive buyer agency agreement.
So why do you think that is so important, this exclusive buyer agency agreement title?
Well, keeping in mind the fact that we've already talked about the Working with Real Estate Agents brochure, we've talked about creating verbal buyer agency, and the fact that verbal buyer agency has two problems. One is that it is not binding, and secondly, you can't bind someone for a period of time. Both of those can be taken care of in the exclusive buyer agency agreement, and by binding someone, I mean you're going to get paid if they find a house during the course of this agreement.
Okay, so when I want to make sure that I/my firm are the ones that the buyer has to use and that I'm going to get paid, this is the form that we want.
Absolutely. That's
Okay.
the essence of exclusiveness, and in fairness to the buyer, I think we owe it to them to explain that that's what they're signing.
Okay, makes sense to me. All right, well, I always think that one of the most important parts to point out to people is this idea that this is not a contract between me and the client. It's a contract between the buyer and the firm. The firm is who they're actually hiring. So if for some reason I decide to get out of real estate or I join another firm, there's not a guarantee that I'm going to be able to take my client with me. That's something that you need to talk to your BIC about. What happens when you join a firm if you leave or go out of business? That just needs to be a conversation.
Yeah, and completely valid and important point, because we know that the commission tests on your understanding of this. Remember all the things we talked about in our notes. For example, what happens if an agent of a large firm dies? I don't want to be morbid, but the fact is that the firm retains the listing, in this case the buyer listing. Also, as Kandyce said, if in fact you leave and go to another firm, it's not automatic that you can take that buyer with you, because the buyer always belonged to the firm according to this agreement.
True. All right, so our next section, what I think it's important to point out is that the buyer is saying, yes, I did get the working with real estate agents. And they're also saying, I'm not working with another firm. Right?
Again, hugely important, because just because you're not with your buyers on weekends doesn't mean that they're not out looking at real estate. So the question you're asking here is, have you already entered into this agreement with another agent? It would be a bad situation in most cases if a buyer was under multiple exclusive buyer agency agreements. So this is where we're asking them and getting their acknowledgement of it.
Okay. Our next section, we have a box where we're saying, hey, am I helping this buyer find a residential property? And let's go ahead and say residential property, or am I helping them do a commercial property? And what they just need to do is check one or check both.
Yeah, and as we talked about a little bit earlier, although exclusivity, you would normally not have multiple exclusive agency agreements. Do you see here how it would be possible that you would have a multiple exclusive agreement? So for example, if I were to do a residential transaction, I would most likely want to do a transaction with someone who specializes in residential. Having said that, oftentimes people are moving to our area are also buying a business here. They would want a separate agent for commercial. So hey, it's actually possible that they would have multiple exclusive agreements that would make sense based on the type of property they're looking for.
I also think about, well, what happens if I have somebody who hasn't decided between Wilmington and Raleigh? So when you've got this general location section, maybe you're putting in Raleigh, maybe you're putting in Wilmington. I mean, you want to talk to the BIC about how do I fill this out to best protect our interests? Because even though I live in Raleigh, I may not want to be selling a house in Wendell because I know nothing about Wendell. So just a good point, we should know that how you fill out the type of property is going to have a big effect on how and when you get paid.
Yes, and in most cases people overlook this, but it could be very, very relevant if you later try to enforce this agreement on someone.
Mm-hmm. So next we have the effect of the agreement, which I just go ahead and point out to the client, you know what, once you sign with me, you are going to have to do all of your business with me. So it says here, by employing the firm as the buyer's exclusive agent, the buyer agrees to conduct all negotiations for such property through firm. And I think really the key word right here is going to be all.
Yeah.
Everything they do, including new construction, has to be through this firm.
Yeah, from a value-added standpoint, I think this is where buyer agents say, hey, look, you just go live your life. Let me handle the negotiations. I will be working in your best interest, so let me handle this so you can go and go about your daily routine. Next section, duration of agency. It's actually pretty straightforward. However, one of the reasons that this is in here is simply because agency agreements are types of contracts, and contracts have to have terms specifically spelled out. So it would not be appropriate to have a firm that was just open-ended. So what the commission requires is that there be a start date and an end date in all agency agreements. So for test purposes, you will see this come up multiple times.
In fact, what does the commission require in all agency agreements?
Well, I like to point out that there's 5 separate things that have to go in all agency agreements. All agency agreements have to be in writing.
Okay.
Now, again, you have to remember the slight exception with the oral buyer agency agreement, but even that has to be reduced to writing no later than the offer to purchase. Right?
Yeah, so it has to be in writing.
All agency agreements must have a start date and an end date.
They must have a start date and an end date.
They cannot be automatically renewable.
They cannot be automatically renewable unless it is a property management contract, but that's for another video.
Yes, correct. However, it is always important to note the differences because that's where that's prime area for test questions. All agency agreements must have standard non-discrimination language, fair housing language, right?
And we'll see that later, the
Absolutely.
non-discrimination
Perfect.
language.
Perfect. And all agency agreements must have your license number. And so you will see that at the end where you put in your license number as the agent who procured the buyer.
Okay, so we know that has to be there. And in this section 3, duration of agency, this is where we have a start date and that end date.
Perfect.
So maybe the most important part of this form is the compensation of the firm. Compensation of the firm. So really, this is something you can talk about later once you get hired. Are you going to charge a retainer fee? Is somebody going to pay you just for you to help them start looking for houses? And if you do get that retainer fee, do they get it compensated or they get it credited back to them at closing or not? So that's a different conversation. We do one of our training videos. Should you charge a retainer fee? So you shouldn't. The big part of this is going to be B. So why don't I let you go ahead and talk about it?
Okay. Now, keep in mind, you're looking at the buyer's agency agreement, and as we'll talk about in this class, as we have surrounding agency, how you are compensated does not determine who you work for. What determines who you work for are your agency agreements. So what we're putting in for B is what we anticipate that we are going to make by being a buyer's agent in this transaction. It's not uncommon in our area for there to be a certain number that we see come up. I'm not going to guide you on what those numbers are, but for
this example, can we say I want to get 5%?
For example, we can absolutely use that.
Okay, so I'm going to say 5% of purchase price. Gotta love my handwriting. And notice there are some guides down here. It tells you could put in the percentage of the purchase price. It could be a dollar amount. You're gonna figure all of this out when you have a good training class, right?
Yeah, but the key there is this is what we anticipate making in this transaction. But then it gets really interesting because we are typically paid out of the seller's end of the transaction. So when you go down to the first little one there, that little I.
The firm shall seek the fee from a cooperating listing firm or from the seller if there is no listing firm. And most important, so much so, let's put that in a different color. The buyer agrees that the firm shall be entitled to receive. No, that's not what I want to say. So I'll stop where I said and most important.
Yes, yeah. I'm going to pick up on that point. So in 4B1, basically you're saying, hey, look, in most cases I'm going to get paid by the listing side of the transaction, whether from the seller or from the listing agent. But then when you jump down to is it 2?
It's
okay.
2.
It does actually suggest to the buyer here that if I'm going to receive less than what I suggested, remember 5% a little bit earlier, if I'm going to receive less than that, or if there's no compensation offered by the seller or the listing agent, then the buyer will in fact pay me for the 5%.
This is a huge point. I don't care if it's for the test or real life. I really do think that buyers should understand I'm going to try to get paid from the listing firm or the seller. But you're agreeing, buyer, that if that is not 5%, if they're only offering me 2%, you're going to pay me the difference. If you decide to buy a FSBO property, a for sale by owner, then guess what, buyer? You may end up paying me this 5%.
Yeah, not only is that important, but I think it's fair that the buyer should understand that. And too many times there's actually been a current lawsuit on this because a lot of buyers' agents are using the verbiage that says something to the extent of, well, if I act as your buyer's agent, you don't pay me anything. And the interpretation of you don't pay me anything is kind of vague. If you look at it, it's coming from the seller side. Well, it's built into the transaction, so technically is the buyer paying you? And then certainly under the language of 4B2, the buyer literally would pay you if there was no compensation offered. So agents need to be careful and fair, I think, about how they present this.
All right. So our next section, this is going to be 4B3. This is, again, having to do with our licensing laws and commission rules. We know that the commission says anytime that you're getting other monies, you have to let your client know, right? So right here, in here it says, if additional compensation, incentive, bonus, rebate, or other valuable consideration is offered through the MLS or otherwise, the buyer will permit the firm to receive it in addition to the fee. But the firm also has to timely disclose the promise or expectation of receiving any additional compensation, which is the fancy way of saying, yes, buyer, you're agreeing that I can have it, but I also have to tell you in advance to receiving it that, hey, I'm expecting it.
We could spend a long time, as a matter of fact, we do in my class, you know this as well, that if I were you, I would recommend writing in the margins here, compare to Rule 109. And later when we talk about Rule 109, we will go into extensive explanation of this. Rule 109 has to do with third-party compensation. And if you're the buyer's agent, most often you are compensated by a third party. And so we will spend a lot of time on that at a later date.
Okay. So our section C, and I think, again, very important. This whole first page is pretty important when it comes to testing, is it not?
Yeah, there's a lot that we will fly through a little bit later, but the first page, page and a half, really has some important language for real life and for test purposes.
Yes, that is true. So this is how you know you have gotten paid or that you will get paid, because you have earned your commission when that buyer, and we'll go ahead and highlight this, directly or indirectly enters into an agreement to purchase, option, and or exchange any property of the type described above. So buyer, if you agree to buy something, if you buy something, I've earned my commission.
Okay, let's put 3 points together to tie it together. So first of all, we have the exclusive buyer agency agreement.
Yep.
We have a period of time, and then we have this comment here, which basically says if the buyer buys anything, regardless of how they buy it, during the term of this transaction, that I, the buyer's agent, am entitled to it. So think, for example, someone goes to a for sale by owner and they say, well, I don't have my agent with me. I don't have to worry about compensation. Maybe I can save a little bit of money. Well, maybe they will save some money on the purchase price, but then the buyer's agent has a right to go back and say, hey, I'm entitled to the 5% that we agreed to.
And please pay me.
Extraordinarily important for buyers to understand that, especially with our market where we sell so many new homes. So buyers can be out there on weekends looking at new homes without their agents entering into a transaction. If the seller doesn't agree to pay the agent, then the buyer is on the line for that agreed to commission. Very
true.
important.
Well, then what's going on in this section 4C2?
I don't want to spend a ton of time on that other than to point out that there is what we call an extender clause or protection period clause. And in regards to this, there are circumstances that come up where a buyer may end up having a agency agreement that expires, but they go back and purchase a property that the buyer's agent actually showed them during the term of the agreement. If that is the case, this paragraph actually protects the agent for their compensation. And let's be honest about this. Buyers are not stupid. If they're coming up on the end of an agency agreement and maybe they say, hey, if I wait another couple of weeks, I don't have to pay the agent any compensation, or the agent's not going to be compensated. Maybe I could use that to my advantage. The protector clause actually extends it. Now, keep in mind, these are only properties that were shown to the buyer during the term of the agency agreement.
And I like to point out that it's blank, so it's whatever you negotiate.
Great point.
Right? So moving on to page 2. Again, I think we should go ahead and point out what's really, really important here. And that's going to be that do not expect a check handwritten from your client to you just because you found a property. In fact, we know if you're an agent, especially if you are a provisional broker, you can only get paid through your BIC, your broker
Correct.
in charge. And that payment's going to be due and payable usually at the sale or the closing, or if the buyer defaults. Now again, if somebody defaults, good luck getting paid. But legally, if they were to default, they will owe you that money immediately. Otherwise, most of the time, you're going to get a check after settlement when all of the parties meet and the money's exchanged hands. And then after recording, after that attorney that's hired by the buyer goes through and records the deed of trust, the general warranty deed, then that attorney's going to come back and write checks to the firm, and then the firm's going to go ahead and write you, the provisional broker, a check.
Yeah, it's interesting. When we talk about the listing agreement, we will revisit this because listing agents have some abilities that buyer's agents do not have. I often tell the class exactly what you just said, it just in a little different way, and that is that if you don't close, it's not likely that you're going to get paid, even though legally you may be entitled to the compensation. Buyer's agents are typically paid a success fee, and that means what it sounds like it means.
So notice you've got this blue note, which means it's got to be something important. And in this case, I want to remind people about the Sherman Antitrust Act, which says, hey, we cannot preset any kind of commissions or fees or charges. That's the Sherman Antitrust Act, and there is no price fixing. So whatever you're getting paid is negotiable between you, your buyer client, and your firm. You cannot say, well, the average in the area is this, or what people normally get paid is that. What I would suggest saying is what I am charging, what my firm charges. Because you know what? As I say in class all the time, nobody looks good in prison orange.
It's interesting that you bring up that part of the blue. The part I bring up about the blue oftentimes in class has to do with the conflict of interest, because I often ask my class, I'll say, hey, would any of you ever be involved in a conflict of an interest? You're an agent, so you'd never be involved with a conflict of interest, right? And they all agree, well, no, I would never do that. Mm-hmm. Buyer agency is, in fact, a conflict of interest. And the reason for that is I get paid more if I'm being paid on a percentage basis. I get paid more the higher that the buyer pays for the property. So literally, I have to act against my own interest to try to get the buyer the best end of the transaction.
Well, I will say I do cover that, but I usually cover it
Okay, go ahead and jump ahead.
In Section 5 when we talk about other potential buyers. Mm-hmm. I point out that, hey, buyer, you're working with me. You've hired my firm, but you're working with me. And there could be 20 other people in my firm. If you're looking for a 3-bedroom, 2-bath house under $400,000 any place in the triangle, there's probably a good chance somebody else in our firm is going to be looking with a buyer at that house. So there could be some conflict there. And the other conflict is, you know what? The more offers there are, generally the higher price the house is going to go. And that means there's more money that the firm is going to get. Mm-hmm. So I want them to truly understand the conflict between other clients that the firm might be representing, as well as if there's any kind of competition. Even if there's not, the more they pay, the more the firm's going to get paid.
Yeah, well stated. I don't have anything to add to that. Perfect.
Okay. Section 6 is the firm's duties. And you're going to go ahead and read this. You already know what it says. You're going to perform all the terms of this agreement. You're going to help them find a property at the price and terms acceptable to them. But really, what I like to point out is this: presenting all offers in a timely manner, right? We're going to make sure that we don't lose any monies. So loads, the loyalty, obedience, accounting, disclosure of all information, skill, care, and diligence. Not only do we have to provide that because it's, agency law, we're promising to do it. And I know you've seen these words before. You're going to share all those material facts. So this is literally just putting into writing what we already know, something that we were already going to do because we understand how agency works in North Carolina.
Right.
Want to add anything there?
Nope. Perfect.
All right. Moving on. You've got Section 7, our disclosure of buyer's name and mailing address. Now, both of us being avid Carolina fans, go Heels, if one of us had our house on the market and an offer came in from Coach K from that school named Puke, what would happen to your sales price, Chris?
Well, certainly if I look at the name on the other side and I know that they are well vested and have the capability, it could affect my negotiating position on that and how strongly
He's
I hold
nicer
the
than
house.
me. I'm saying that price is going up because go Heels, yay State, can't say anything about Duke. But there's a chance that your client, your buyer client, doesn't want people to know, hey, I have a lot of money. Because if Oprah were to offer for my house, I probably wouldn't be willing to negotiate because I know she's worth more than me. Right, so this is just letting them know, if you're putting in an offer, unless we make other arrangements, your name will be out there.
I often cheat on this in the field, and once it gets too complicated, I just tell the agents to seek legal advice on this. If someone wants to buy the property as an LLC, a corporation, or an undisclosed client, then I just want to make sure that they have the capacity to be able to do it, and the right people are signing it, and the trust or the LLC is set up appropriately. So I send them straight to the attorney on that.
My favorite saying in class is CYA, call your attorney.
There you go. Perfect.
Our Section 8 you talked about earlier. What did our Section 8 discuss?
Well, this is the standard non-discrimination language that I was talking about a little bit earlier. A couple of things that are interesting here. This is one of the 5 things that have to be in the agency agreement according to the Real Estate Commission. And notice also that it's in all caps and bold printed. Anytime that you see something that's like that in a contract, it's because there's a corollary rule that says it must be set aside in such a way that it draws attention to itself. In this case, it clearly does. If you'll read that closely, you will notice that it does include all 7 of the protected classes. If you have not gone over the fair housing chapter yet, then that will become blatantly obvious to you at that time that there are 7 protected classes. But then notice also at the end, there is a class that's not protected by fair housing laws, but is in fact protected under the Realtor Code of Ethics, and it has to do with sexual orientation or gender identity. That this contract, we are also agreeing that we will not discriminate on that as well.
So Section 9, the buyer's duties. This is not the class that we're going to talk a lot about this, but the buyer does promise to do what they're supposed to do, pay people, be available for negotiations, showings, anything like that.
Section 10 talks about other professional advice, and I think this is a really interesting point for stating what we do and what we don't do. I've often told agents that on the buyer side, we are more project managers is what we are. And so we're going to help the buyer find the resources that they need. And we're also going to make it evident that they need to pay for these resources. For example, home inspections, surveys, et cetera, et cetera. What are you pointing out there?
I am pointing out the fact that the buyer is advised to seek professional advice in the matters of law, taxation, financing, insurance, surveying, wood-destroying insect infestation, structural soundness, engineering, building construction, and other matters pertaining to any proposed transaction, right?
Yeah, it seems awfully wordy to say all that. And good gosh, when you look at the offer to purchase at paragraph 4 of the offer to purchase, it goes into detail about these. And you wonder, why do we feel like we have to say this? Literally to the point, why did the attorneys feel like it needed to be in here?
Because people don't realize it. And in fact, we have to point out, not only do they need to get those services, they need to pay for them, not one of us.
Correct. And then later, down at the bottom of your 3 bullet points, you'll see there's a form there that we recommend, the Professional Services Disclosure and Election Form, that actually allows you to, when you recommend a service, have the buyer acknowledge that they either want to choose that service or waive their option on that. Again, it seems like it's a lot of time and effort to spend, but there have been lawsuits based on the fact that, well, why didn't my agent suggest that I get a radon inspection, a structural inspection, etc., etc. Again, other professional advice here, there are people that are better versed than you as an agent. As an agent, let's turn this into a test question and remind you of this. Agents are responsible for what they know or what they reasonably should know.
That is true.
If you're not changed in law or structural integrity, you should not comment on those topics.
So they're not responsible for the latent defects, but they are responsible for the patent defects.
Yes.
And we have this Professional Services Disclosure and Election Form, but as a great agent, you're going to make sure that you give them the offer to purchase and contract, the questions and answers on home inspections, which is written by the commission, and of course that Professional Services Disclosure and Election Form, right?
Perfect.
So a home warranty. How do you explain a home warranty to people?
Well, to be quite honest with you, I don't spend a lot of time on it in the buyer agency agreement, other than to say that this may be something that we want to consider in regards to our negotiations. Oftentimes we can get a seller to provide one. If the buyer would like one, we will discuss that and talk about some of the options that are available there. But this will be a significant part of the negotiations at the time of the offer.
It will, and if we're looking at it from a test point of view, we do like to remind you that any kind of monies that we're taking, we've got to let the buyer know.
Oh, great point. Going back to Rule 109, oftentimes there are compensation from these third parties that we would have to disclose if you choose to take them. Great point.
All right. So confidentiality of offers. Now, Chris, in your opinion, what are the chances that they're going to have a test question on this?
100%. Yeah, 100%. And it's interesting, if you read this paragraph, it's actually misleading, because during class we will talk about the fact that as agents, you will not disclose the terms of competing offers. Is that Rule 115?
I think it could be Rule 115, but we can look that up
later.
Yeah,
look that up a little bit later. I promise you we will nail it down in class, and here's why. Notice again what the language was. The language says that agents will not disclose the terms of competing offers without the permission of the person who made the offer. Now, when you read this paragraph, it tells the buyers not to assume that your offer is confidential. Well, that doesn't make sense. If we just said that agents couldn't disclose the terms of competing offers, how are they not considered confidential? What could happen? Sellers could disclose it.
That's exactly right.
Sellers could disclose it. So don't assume it's confidential, but I promise you it won't be an agent
exactly
that does it.
Okay, well, moving on, we've got our additional provisions, which, you know what, since this is pre-licensing, I'm going to tell you, don't touch it.
That would be my preference at this point.
Please don't touch it. And then we get to dual agency. So we know from previous classes that there's different roles we can have as agents. We could either be an exclusive agent or a single agent. We could be a dual agent. We could be a designated dual agent, or we could be a seller sub-agent that's working with a buyer. And although we've taken this class and we understand all of this, when we're sitting down with our clients, we need to be clear that, hey, buyer, what you're getting ready to sign with me is an exclusive buyer agency agreement. You're hiring my firm, and my firm will exclusively be looking out for you. However, there's a chance that you might want a house that is being listed by our firm. Now you've got a buyer, the buyer, who's being represented by our firm, and then you've got the seller also being represented by our firm, and that would be dual agency. And if it's dual agency, we know that we must have consent. In fact, as the buyer's agent, whether it's oral or written, you have to have that permission before you can even show the house.
There are so many places on the test that this is going to come up. We really can't get into all of them right now. However, in working on the buyer agency agreement, what Kandyce said is exactly correctly. in fairness, and if you want to write down another law, 93A6-4 says that an agent cannot work for more than one party in a transaction without the consent of both parties. So what we're asking here is, hey buyer, if dual agency comes up, will you allow us to do that? I will say, I don't always love the way that attorneys write, but the dual agency paragraph is very, very well written.
It is.
To explain this.
So in class, I usually like to point out that when you're the buyer's agent, you're going to have your buyers either say, you know what, yes, you can be a dual agent, or they're going to say, no, I don't want dual agency. I want exclusive representation. There is never a time that you're going to check both this line and that line, or they're going to initial. It's either 1 or 2. Either they're signing on the first line or the second line.
Perfect.
Okay. Now, if they choose this first line and said yay to dual agency, they get to choose whether or not they want designated agency. So a buyer could possibly choose the first line, or they could choose the second line, or they could choose lines 1 and lines 3.
Okay, and what I meant by we will not cover it a lot in this lesson is that we spend a lot of time in class talking about what it takes to create dual agency, what it takes to create designated agency, the advantage of designated agency. So what Kandyce is pointing out here is the technical part about how to complete it. Now, as a broker in charge, having seen hundreds and thousands of contracts, that's hundreds and thousands, not 100,000, but seeing a lot of contracts, I see that this is done incorrectly. Kandyce, you know what the most common mistake that I see?
What is it?
All 3 of them initialed.
Ugh.
Now, here's what I know about that. An agent did not explain dual agency. If a client initialed all 3 of those,
they didn't understand what
they didn't
going
understand
on.
it.
No.
My guess is probably what happened was that they were doing a DocuSign or .loop document, an electronic signature, and they just clicked and scrolled. Now, keep in mind, I did describe to you a little bit earlier that dual agency, undisclosed dual agencies, not just against the commission rule, it's against the state law. It is a Class 1 misdemeanor. So it's possible something that you could be fined by the courts for an undisclosed dual agency, and you would almost certainly forfeit your compensation if you were in dual agency without the informed consent of the parties. This is extraordinarily important.
This is very important, and I got to say on a personal note, it drives me batty when people can't get this right.
I agree with that.
Okay. Moving on to our section F, the dual agency compensation. Go ahead with that.
I'll make this really brief for you. The dual agency compensation, no one understands this paragraph. So I'll explain to you what it means, and then in the future, if you're ever working for me, what I'll do is I'll tell you what to put in there and just let it ride. Keep in mind, we're looking at a buyer agency compensation, and we owe it to the buyer to disclose to them the extent of the third-party compensation that we are receiving in a transaction. So Kandyce mentioned a little bit earlier, as a buyer agent, I'm expecting to receive 5%. Well, in a dual agency situation, my firm, remember it's the firm that is the party that's involved in this transaction, the firm would actually be receiving maybe 10%. So what we disclose to the clients here is the extent of how much the firm will be receiving only if dual agency applies. So Kandyce, write 10% there, so we'll have a placeholder for it.
All right. Put 10%. Yeah.
Okay. If dual agency does arise, then that's what we expect the firm to receive. Now, I promise you, 100% of the time, if a buyer looks at that line, they'll say, wait a minute, why are you making 10% in this transaction? You'll have to explain to them that the 10% will most likely be split between you and a listing agent. But this is a requirement because the Rule 109 does state that you have to give the full extent of your third-party compensation, and that's all we're doing there.
All right. So let's just finish this contract up. The mediation just says, hey, you know what, buyer, if there's a problem, let's try to mediate it before we go to court. We know this is the entire agreement, so any changes that we want to make need to be written. Right? Surveillance, now actually when we get to a post-licensing class, I think we should talk a little bit more, or a CE.
I think so.
But keep in mind that the laws say if you're going to be recorded, you have to give permission for oral, for the audio. Somebody can record you and it can be visual, right? But the audio, you have to give permission for that.
Yeah, and I would think in this day and time, this may be just a tip for you. I doubt seriously if it comes up on the test, but a tip for you if you're acting as a buyer at this point, you should assume that you are being videoed while you're in someone's house today. It's so simple to do.
Yes, and then our photographs and video says, you know what, there could be video, there could be photographs, and buyer, you can only take a look at things that are in plain view. This is not the time to go snooping under people's beds. Now, opening a cabinet to see how much space there is, that's one thing. But opening somebody's underwear drawer, not allowed.
Yeah.
Okay.
Perfect.
And then our wire fraud warning. Wire fraud, I've got to say, it's been pretty bad lately. And you just want to remind your buyer that if they get any wiring instructions, they need to call and confirm with the attorney's office. Whether it comes from the attorney or us as agents, there's a good chance if it's going through email, it's fraudulent. Always do all of your did I say your wire fraud stuff? But always do your bank wiring information via phone call.
Yeah, I'm getting ready to do a personal transaction right now, and I am so paranoid about this that I will literally probably be on the phone with the attorney at the time that I'm doing the wiring.
I think it's a good idea.
Just to make sure that we have no discrepancies in that. And then having said that, the other way that you know that this is important is it shows up in every agency agreement. It shows up in the offer to purchase, and a lot of firms actually have a separate wired fraud warning.
Yeah.
So that the buyers are acknowledging this. And you know what? Buyers still will occasionally fall for scams on this.
And there may not be a way to get their money back.
Right.
All right, and our last page is where everybody's going to sign. Remember, if it is an entity buyer, they're going to sign on behalf of that entity there. And I think that's pretty much it. Anything else you want to add to this?
Just the only thing I'd like to add, we told you that there were 5 rules, and you've seen them by this point, that they have to be in writing, they had to have a start and an end date, it had to have standard non-discrimination language, it can't be automatically renewable. And look at the last page there, where it allows you to put in your license number. Why? Well, because the Real Estate Commission said so. And actually, that's an acceptable answer. If the Real Estate Commission says so by rule, then you have to do it.
Okay, well, I hope this helped. This pretty much covered anything you may see reasonably on the pre-licensing exam. Now, again, you are responsible for the whole form, but these are the major points that I think come up a lot. Yes?
Yes, and I'd like to reiterate what I said at the beginning, and that is simply when you're looking at this form, please always relate it to something else we talked about in class. We did not do service to dual agency in this because we were talking about the mechanics of dual agency, not the theory of dual agency, which was a whole 2-hour lecture in and of itself. Relate it back to something that we talked about in class.
Maybe we'll do a lecture on that later, a
Perfect.
video recording.
Perfect.
Okay, y'all have a great day.